There was no prayer before the Supreme Court to build a temple for Ram in Ayodhya.
That the land itself is a spiritual entity. Bhagwan Ram is the first plaintiff, the second is the Janmasthan. So there is no prayer for building a temple at all. None of them could assure the court that prior to the demolition, prior to the construction of the Babri Masjid, there stood a Hindu temple.
Sunny Deol, Tariq pe Tariq pe Tariq. A litigant gets frustrated at the date after date after date.
See, the track record has been uneven. It's difficult for us to say the court has not been responsive at all.
Hello and welcome to TheFederal. You are watching Off the Beaten Track and I am Nilanjan Mukhopadhyay. Out of the various wings of the Indian state, people have a lot of faith in the judiciary. They normally do not trust the executive or the people who are working in the government. Certainly not the legislature because it consists of politicians. And generally, all surveys say that people do not have a very high, opinion of people who are in politics. The judiciary is, of course, much respected. The fourth, arm of the Indian state of the state, that is the media. Unfortunately, in the last 10 years, we have become, in the minority. We meaning, the our section who are the non-mainstream sections of the media are somewhat in the minority. By and large, the mainstream media is also looked as an entertainment platform, not really in terms of providing news and correct opinion. So I want to talk about the Supreme Court because this is the year when it has completed 75 years. It's a very important year. And I have reached out to Justice S. Muralidhar, who is a very formidable voice in the judiciary, somebody who has been the Chief Justice of the Orissa High Court, someone who has been a judge for long years, almost a decade and a half in Delhi High Court and thereafter the Punjab and High Court. A fairly turbulent kind of a innings as a judge in the high courts of various states. Anybody can find out, and I'm sure that you would remember that when he retired from the Orissa High Court, people really felt that they were actually losing somebody who they could really trust. He now currently is a lawyer and practices in Supreme Court and wherever he has to appear. Welcome to this program, Justice Muralidhar. It's really a pleasure to speak to you. There are two reasons as to why we are speaking to you. One is that quite recently you came out with edited compendium, a book, which is very mysteriously titled Incomplete Justice. The word in is within brackets.
That's
Complete
right.
Justice, the Supreme Court at 75 Critical Reflections. These are collections of essays by very eminent people across the board, looking at people who are active in the field of law, people who have written about law, journalists, opinion makers, various people are there. The other is that you have also been speaking, you delivered a very powerful lecture, the A.G. Noorani Memorial Lecture, where you raised some very important points about one of the biggest issues which is dogging the Indian state, that is majoritarianism, and how the judiciary has approached it, especially the most important issue or the case involving this entire field of religious conflict between various communities of people, that is the Ayodhya case. That was to a great extent the focus of your judgment. So, welcome to the program and thank you very much to take out time to speak with us.
Thank you.
I would like to begin with why incomplete justice? A very elementary question, but I'm sure that there would be layers and layers of explanation which you would be able to provide. Please.
See, when we started functioning in independent India, we inherited a judicial system which was given to us by the colonial masters.
Right.
And we took it on with all its inherent issues. The issues of delays, uncertainties, unrecoverable costs, these were there at the very inception when we took over as a free country. And we've had to live with these elements throughout these 75 years. And many a person I know feels that when the case is at an end, there are only more losers than winners. And there is, even for the person who ultimately wins the case, a certain brooding sense of injustice that it has come too little, too late. So this question remains in many of us. Were we able to deliver through this judicial system complete justice? It is
Okay.
possible that some people view it differently. I'm not discounting the fact that some might say, given all its faults,
Sure.
we are still able to get some justice delivered at some point in time. And given all the constraints, we can't really find fault. So there could be different perspectives on this issue of complete justice. So in is therefore in a bracket because of the perception of persons. Uh, they can have differing points of view. Many of it could be subjective. As judges, we are able to take a more objective view, but as a litigant, it can only be a subjective point of view when you don't get your day in court. So this
Right.
title captures the differing perceptions one might have at the end of this whole process of reviewing the working of our judiciary and particularly the Supreme Court of India over 75 years. So I've left it for a point for discussion and debate instead of fixating on what I feel or what somebody else
Right.
might feel about the performance of the Supreme Court of India, definitely, and of the judiciary as a whole.
Well explained. And as you were explaining, I was reminded of this very famous dialogue which was said in one of the very popular Hindi films of the 1980s, or maybe it was 1990s. A sequence which was enacted by Sunny Deol. Tariq pe Tariq. A litigant gets frustrated at the date after date after
Correct.
date. So as you
Correct.
said, that finally when victory comes, it is very pyrrhic in nature. That is the biggest problem, that I really
Yeah.
do not want this kind of victory. That is always there. And as citizens, we have all had our you know travels with the judiciary. As a journalist, I have also had my share of tariq pe tariq pe tariq. We shall not talk about it, but yes, definitely you have a point where you say.
Can I
Now,
add can
yes,
I add one
please.
element to it? See,
Sure.
there is a provision in the Constitution, which is Article 142, which only permits the Supreme Court of India, no other court, to pass orders which it considers necessary in order to do complete justice. So, over the 75 years, there have been numerous instances where they've used this power to forge a relief or to mold a relief, as lawyers would say, which is quite different from what could have been the logical outcome of a case. So they've, for instance, mandated, just to give you an example, that appeals from the Central Administrative Tribunal's decisions will not lie directly to the Supreme Court of India, although the statute which created those tribunals provides for it. Even today, if you pick up the Administrative Tribunals Act, it does not provide for a remedy in the High Court. Whereas using this Article 142 power, the Supreme Court has created a
Okay.
tier of judicial review which does not exist in the law. So they've justified it by using their orders, powers under Article 142, and they say this is in order to do complete justice. So when we look at many such instances, we find that there is an incompleteness otherwise, which the Supreme Court viewed as completing. But what we find is even that is incomplete. People will tell you that even the High Court is now flooded with petitions arising from orders of the Central Administrative Tribunal. It has delayed resolution of issues. It has added to litigants' costs and waiting time. So what the Supreme Court may have thought as doing complete justice has actually added to the incompleteness of the justice. So this is another angle to it.
Right. Uh, well, explained further. Now, 75 years of the Supreme Court. Obviously, as a journalist, I have not written mainly on legal issues, though there have been occasions where I've actually tried to study legal proceedings, especially in the areas where I've been particularly interested in or where I have actually written extensively. But the first question which comes to my mind, to what extent has the Indian judiciary, has it really been able to uphold the foundational principles of our republic? We really want to know that how much of it, the Supreme Court, for instance, last year it was given a new flag, a new emblem. So one of the things is there, the constitution is there in that, besides the Ashok Chakra, the wheel of law and the book of the only holy text of India. That is what the Prime Minister, Mr. Narendra Modi, calls it. So, how much of it has been upheld by the judiciary?
See, the track record has been uneven. It's difficult for us to say the court has not been responsive at all,
Right.
because at various points in our legal and political history, we have found the court, some quarters in the court, some of the judges responding to that crying need for some introspection, for reaching out, like this whole PIL jurisdiction, the public interest
Right.
litigation jurisdiction, which our Supreme Court has picked up from the US and the US courts particularly, but has developed on it quite significantly. So there is that element where the court reaches out to the people, conscious that many of them can't reach the court. What that jurisdiction has become is another issue for debate. In fact, in this book, which you spoke about, Professor Bakshi reflects on all of that in my interview with him. And he calls it, he likes to term it as social action litigation rather than public interest litigation.
Public interest.
Because he says the original purpose was connecting with the people and seeing how their issues can be addressed. And when he talks of people, he means the less advantaged and less privileged sections of our population. If you also pick up some other issues, like, for instance, sexual harassment of women in the workplace. Now, the court has stepped in to push for the change in law.
Right.
It gave a remarkable judgment, which has resulted in now a statute made by Parliament. But that
You're
gap,
referring to the Vishaka case.
correct,
If I'm
the
not
gap between the pronouncement of the judgment and the statute was covered by what the Supreme Court laid down as guidelines. So that was a very positive step, because also the Supreme Court drew on international conventions, the human rights law, and to which the India is a signatory, a treaty party, and drew on those principles to develop the law. So there have been numerous such instances where the court has acted who has been proactive, and has made a real change. It's easy to dismiss off saying that this is a court which is unresponsive, but has it been able to do it consistently is one. Has it been able to do continuously is another problem. So judges come and go, and this I tried and explained to many audiences, that unlike the Supreme Courts elsewhere in the world, let's take the Supreme Court of the United States or the UK Supreme Court or the Australian High Court, they all sit en banc, which is judges sit together. Sometimes there may be divisions, but usually they sit in a minimum quorum of 5. And in the US Supreme Court, it's always the 9 of them that sit together. Whereas in the Indian Supreme Court, we have 34 judges. And we sit in at least 15 to 16 benches. Like today was a Friday and we had 17 courts sitting and benches of 2 judges. So this can result in multiplicity of opinions, multiplicity of variances between judges on how they address the same issue. So this is a problem, I would say, which is peculiar to the Indian Supreme Court, which is also hindering the proper development of the law in the way it should get developed. So this is an added feature of how we view the court. So to answer your question, it's a mixed track record. I think the court could have done better. This is what I might feel. Somebody else might feel something else. And I would say that they have planted in this whole journey many seeds for that introspection and reform and progress. So judges, several generations of judges pass by us. Some of them can pick up and nurture those seeds and help them grow and help the law develop in a more positive way. That's the hope and expectation we have even today of the Supreme Court.
Um, this point you were saying that large number of judges, 34 judges in the Supreme Court. Now, given India's size, population, and the number of cases which are, there is always a backlog. I do not remember even for a single day, even from the years before becoming a journalist, that people have always complained of very high backlog. So maybe we need to have more judges, so there is going to be a greater number of voices is going to be there. So I think it is something which will there will be differences of opinion, many shades of opinion, all that would be there. Now, India was born in out of religious conflict, if I can actually say it that way, that we had, the largest possible human migration happened because of that. A lot of, violence and bloodshed, innumerable number of people who died. Majoritarian politics, had a definite mark right from the beginning, and religious conflict always was an integral part of our polity. There were large periods when it was put down by political leaders, and there were times when it was actually used by political leaders, and also people reacted on their own. Not always it would be right to say that the politicians were the only ones to be blamed. I myself have covered numerous communal riots, and I would say that there have been times when even the most trivial issues have sparked off a massive communal violence. There have been, of course, much more organized communal violence, like the 1989 in Bhagalpur, or the ones in Meerut in 1987, or later on. Those kinds of the Muralidhar in 1980. They were all planned instances of communal violence. So what we are trying to say, this majoritarian onslaught has always been there. I have personally had some kind of an experience about how the judiciary has gone about listening to these cases which have come from these areas. I wanted to check with you that what is your opinion of how, to what extent has the judiciary been able to tackle this majoritarian push, and also in the last 11 years, this push from the Indian state?
Yeah, again, at various points in time, the response has been uneven. But if you look at the major landmarks,
Yes.
I would say the Keshav and the Bharti case itself, the famous fundamental rights
Yes,
case,
of course.
13 judges sat together to identify what are the basic features of our constitution. One of the things they definitely picked up was secularism. And it seems that they were responding to a need to define what can't be changed in our constitution. So if you look at the Constituent Assembly debates, and I mentioned this in my recent talk, there was a concerted move by one of the members of the Constituent Assembly to say our constitution should begin with the words, "In the name of God, we the people."
Right.
And there was huge resistance from the remaining members of the Constituent Assembly.
Mr. Kamath, if I'm not wrong,
That's right.
you
And
say that in
Purnima
the
Banerjee's,
Indian
yeah,
name.
Purnima Banerjee's very pointed response, please don't ask us to vote on God, who's a
Right.
neutral entity. They were clear they didn't want a constitution similar to what was being drafted for Pakistan or the Irish constitution. We borrowed several elements of the Irish constitution into our constitution. But this opening part of the Irish constitution, where they're praising Jesus Christ and invoking God, we didn't want to go down that path. So somewhere, I think right from the beginning of the making of the constitution, we wanted to clearly state that we were going to be secular in our outlook, in our constitutional values. And that got properly affirmed in the Keshavananda Bharti case. And then 20 years later, when the occasion arose for the Supreme Court to review the imposition of President's rule in 4 of the BJP ruled states following the destruction of the Babri Masjid, while approving the imposition of the President's rule in those states, they again had an occasion to state very clearly that secularism was part of the basic structure of the Constitution.
Right.
And these are by benches of 13. Bommai, the case I'm talking to you about is
Yes.
S.R. Bommai.
What's called as the S.R. Bommai case.
By 9 judges. And although, as legal scholars, it's sometimes difficult to find out what are all the judges saying, this much is clear that in the Bombay case, all the judges were agreed on secularism being part of the basic feature of the Constitution. Now, how that has progressed in individual cases, and my talk was on Babri Masjid case, or in some other case like the Shabarimala case, or the judgment concerning the wearing of hijab by young Muslim girls, you can see the differences in the approaches among the judges. Like the Hindutva judgment, there was a series of
The
judgments.
1995 Hindutva,
That's right.
Hindutva is a way of life.
Correct. Electoral malpractices, seeking votes in the name of religion. They had an occasion to explain what was seeking votes in the name of religion, if it was going to be Hinduism. And in those speeches, if the word Hindutva was used, whether it amounted to seeking votes in the name of religion. And Justice Verma's opinion that these are not antonyms, but more like synonyms, created a huge problem. And this was the ascent of the Hindu right wing in the country politically. And it was taken advantage of. And many a scholar has been critical of that judgment, saying it changed the course of political history. It may not have been the only reason, but certainly it gave a certain push in a different direction. So if these messages keep coming from the courts, which are at variance from our constitutional value of secularism, it's a matter for concern. So this is where we are, that we are at a stage now where some of the judges are making a very strong statement about the belief they have in the constitutional value of secularism, and are explaining to us why it's important to uphold it, whereas certain other judges are veering away from it. This is a subjective viewpoint. People might disagree with me on what I say, but this is what we are saying. Another way to look at it is the Supreme Court reflects the majoritarian impulses. And having been a judge myself in a constitutional court for 17.5 years, I feel that one of our primary functions is to be counter-majoritarian. As a constitutional court, we need those different voices, the dissenting voices, the numerical minorities to have their say, right? This is the democratic space that the Constitution provides for those differing points of view to clash and for something to emerge from that clash. We expect Parliament to do it, but very often we're disappointed to see what is happening in Parliament. Some bills are debated at length, but a majority of those bills are just rushed through. And the latest example, 7 minutes you had this bill rushed through and become law. So this is a serious problem that we have on hand, and that counter-majoritarian role of the court also gets tested when these kinds of issues come up before the court, whether it's Shabarimala or hijab or Babri Masjid and those kinds of cases.
I just wanted to share, an opinion which was expressed to me when I was working on my book on the Ayodhya dispute, and when I was looking at the legal aspect of it. I had a long conversation with Mr. Rajiv Dhawan, who was one of the lead counselors in the counsel in the case, a very senior lawyer in the Supreme Court. So he said that Hindutva judgment as being intensely problematic and possibly paved the way for much of what happened in the Ayodhya case later on. Anyway, this was just an input. I just couldn't avoid sharing this opinion with you. You were talking about the Keshavananda Bharati case and the basic structure of the Constitution doctrine. In the last few years, especially after 2022 onwards, when Mr. Jagdeep Dhankar, who recently resigned as the Vice President of India, he became Vice President. There was a very concerted attack on the idea that there was something sacrosanct about the Indian Constitution, which the Supreme Court defined as the basic structure of Constitution. Not just Mr. Dhankar, but even a union minister, lent support to the opinion that there is nothing like the basic structure of the Constitution, and that Parliament or the legislature is supreme. The judiciary has no power, no right to determine whether our laws, the laws that we as elected members pass, whether it is good in law or not. Once we pass it, it is permanently good in law. This kind of an attack, does it raise some worries in your mind that which way is the Indian, the dominant section of the Indian legislature and the executive leading the nation to?
I think history tells us that this is not the first time it's happening.
Yes.
When Mrs. Gandhi was in power and they had this humongous majority in parliament, they really believed that they should be calling the shots.
Yes.
They said, this constitution itself is a barrier to us. You remember they inserted by an amendment a provision in the constitution which said elections to the offices of the prime minister, president are all beyond judicial review.
Yes. Yes.
They just didn't want to give the courts, concede to the court any power. So even today, after the results of for 2014, 2019, they started feeling, listen, who is this organ? Which is this organ trying to tell us what is good for the country? I've come with such a huge mandate from the people, and you are unelected judges. How can you become wiser than all the people who have elected me into power? So this question is not the first time that a democratically elected government is asking in the world. Every government which comes with a returned mandate of a huge majority suddenly feels that it should call the
It
shots.
is well within its power to pass
Actually,
any law that it wants.
Yeah, this is not the parliament speaking. This is the executive speaking.
Right.
The discipline that they have in the party, right? If Mr. Dhankar goes outside the mandate that he's given, he's going to be eased out. We've seen this happen right in front of our eyes. So this is a single command. That single command that comes from the top. Nobody can step out of line. If a minister is talking, the minister is not exercising his personal point of view. That a strong executive will want to dominate parliament and judiciary is not the first time in our country's history. It has happened before. And if we as people again bring back such a strong government, just look at 2024. There's a clear message given that we don't want one party to dominate, right?
True.
So today we have an NDA government. We don't have a BJP government. It's a different matter whether they don't acknowledge that and say, no, we are still the same. But the people there is an answer given by the people every now and then in history where they say, we believe in the democratic values of our country. We don't want one organ of state to dominate. It's a very clear message. So I don't think I will not get alarmed because I know the people of this country have always told such strong governments where they get off. And if the courts listen to that voice of the people as much as the executive believes it's listening to the voice of the people, the court will also respond likewise and remind itself that it is meant to be counter-majoritarian, and it can assert and will assert that that there has to be that balance in the constitution. So Keshavananda Bharati was a clear answer. It was 1973.
Yes.
Mrs. Gandhi is the peak of her powers.
Yes.
And here are 13 judges, of course, a split verdict.
And she was being advised by a very prominent lawyer, politician, Siddharth Sankare at that time.
And not just, there was a coterie.
He was, he was part of the coterie, but
probably
a lot of inputs were coming in.
Yeah, but I'm just saying that, at every point in time, like look at 1934 Germany, right? The Nazis have come into power. The first thing they do is to amend the constitution. It's ironical that we are borrowing the whole basic structure doctrine from there, because the person, Professor Dietrich, who wrote that, was writing in the aftermath of Nazi Germany, right? They knew what will happen if through a democratic process, you get a brute majority. And that party or that dispensation comes and first changes the constitution. Then you lose the basic elements of a constitution. Right? So this is all a lesson for us from legal and political history. And I hope even politicians are learning from it. Every time this happens, they think they're indispensable. They think they're invincible. But the people have a different answer. So as a democratic institution, the court also should respond likewise. And the court has. See, our Indian Supreme Court has every now and then given that response. It's only a matter of time till we get that response.
Inshallah, as they say. There is, I'll talk about something, which is happening at the moment within the Supreme Court, which is, been slightly disquieting to me. I would like to understand whether my disquiet is correct or not. The Supreme Court at the moment, among other cases that it is hearing, it is also hearing the government reference on whether there should be a time deadline for the governors and for the President of India to to notify or sign on a law which has been passed by the legislature. Now, while this was just an oral observation, the Chief Justice of India said that judicial activism should not become judicial terrorism. Now, I have not been able to understand this coinage and where does this judicial terrorism come from? The moment this is being juxtaposed, judicial activism with judicial terrorism, meaning saying that being judicial activist is actually bordering on the side of terrorism of some kind. So the fear which comes to my mind, are they also pleading for some kind of judicial passivism?
Again, like I said, you see, we have 34 judges. Not all judges think like a few judges may say, let's push the law, right? So that we restore a balance. See, the issue that's getting played out now in the Supreme Court is a situation of imbalance. Right. And why do I call it an imbalance? There is an elected government, popular mandate of the people. The same government at the center, which believes that, nobody can dictate to it what it should do and how it should do, will not allow state governments who just happen to be in the opposition to have their say. So the check that the state governments have on themselves through the constitution is the post of the governor, who is answerable to the central government, right? The governor is removable at pleasure of the president. The president's appointment of the governor is not the president's discretion. President acting on the advice of the cabinet, right? So the lines of control are very clear. So the control that the central government exercises over state government is through the office of the governor, and this constant pinpricks. You exercise what's called a pocket veto, right? Once the bill is sent back, I as a governor send back a bill to the state legislative assembly and say I find these things problematic. The state legislative assembly either
we consider it and either pass it back.
Once it sends it back, you can't sit on it, right?
Yes.
So if you continue sitting on it, and like the Supreme Court has pointed out in some instances for 4 years,
yes,
that's most of the term of that elected government, right? So if it has come on a certain mandate and it feels it needs to fulfill that mandate, it can't be frustrated in this manner. So if that system breaks down, you see, there are silences in the Constitution. Why is all this being argued as an advisory opinion matter before the Supreme Court 5 judges bench? It's because of the silences in the Constitution. It's very easy to point out by the government, for the government to point out to the Supreme Court, show me one provision in the Constitution which says governor has to decide on the bill within 90 days, within 120 days. If the Constitution doesn't say so, how can 2 judges of the Supreme Court give us this time? Logically, it seems perfect, right? Logically, it seems perfect. But the governor is not acting like a governor, right?
Because there is a certain context, a backdrop is very important.
Yeah, because the governor is acting as an extension of a government in the center and not exercising his or her, role as a governor as was written in the Constitution. They thought these would be people who are, like statespersons, statesman type persons who will be, objective, who will be able to understand what is the best interests of the state and who will retain the balance between the executive at the center and the executive in the state. Now, if that balance gets, and you become a mere extension of that political, fight, which we have seen play out in the 10th schedule. See, there's an entire chapter in the book, Complete Justice, on the 10th schedule. It's written by Surit Parsari. And, it's alarming to see the role of the governors in each of those instances. So the governor of today is not the governor that the constitution makers had in mind.
Right.
The office got compromised, I would say, right in the beginning.
And it has happened over years, It's not that as it only started from 2014.
And this en
Yes.
masse changing of governors. See, the playbook has remained the same, only the players have changed.
Right.
So what these people are saying in the center is exactly what we heard in the 70s when Mrs. Gandhi was in power. They've not come up with something new. They're saying this is our time, let's do it even better. And the
Okay.
court is coming in to say, listen, I have to restore a balance. I can't be a mute spectator, right? If the law is bad, you challenge it on the judicial side, you say it's unconstitutional. I can take a decision on that, definitely. But if you don't allow the law itself to come into force, then you're breaking down the constitutional scheme. Then it's a larger issue of federalism, right? Which is also part of the basic structure. One of the
Mhm.
basic features of the constitution is federalism. So this
Mhm.
advisory opinion should actually explain to us whether these moves that are being made and getting played out in the judiciary are actually strengthening our federal character or weakening it. So you can't simply see it as something of setting a timetable for a governor. It's not such a simple issue. And why are governments coming to a court? Because all other means of political resolution are not working out. See, in the court, they say if the governor and the chief minister sit together, they can find a solution. They are not able to find a
They're
solution
not even talking to each other.
because
The
that's the
governor quite
reality of
often
today.
do not have a
Every
dialogue with the
government
chief
ruled by
minister.
an opposition, every government in the states ruled by an opposition has this problem from the governor of that state. Why is that? I mean, it can't be a mere coincidence, right?
True.
So those are not getting fulfilled. That is, those people will actually set apart their differences, sit across a table over a cup of coffee, and somehow resolve. Actually, I must point out here that bench of Justice Pardiwala and Justice Mahadevan, they went through a whole process. It's not that suddenly one day they decided to give this judgment.
No.
They waited patiently. They heard arguments at length. There were numerous occasions when the governor could have come forward to say, listen, I'm clearing this bill. I don't want this impasse to be created. But what was displayed before the court was defiance. To see, let's see what you can do. I'm not going to do it. The constitution doesn't lay down a
No, we have seen some governors
guideline.
actually make such offensive
So,
statements and actually making it very
so there
clear.
is no question of judicial terrorism at all here, right? That question doesn't arise. Like, let's say even the memorandum of procedure for appointment of judges, if the central government sits on the file,
Nothing can happen.
the Supreme Court could have hauled up a union law secretary for contempt. But it's not that law secretary who's taking that call. It's not even the law
Yes.
minister who's taking that call, right? We know now how that whole process works. And at some point in time, you have to pull back because you don't want an embarrassment. But the fact remains, if a government decides not to, obey the order of the Supreme Court, there's only so much the court can do.
No, there have been instances, where they, on the appointment of election commissioners, they enacted a new law. A very questionable law has been enacted, and that is what is the foundation of, the election commission, being under greater public scrutiny, and its impartiality being doubted by people.
Correct. But this is a democracy at work. So
Yeah.
a person like
And
me finds it as providing numerous opportunities for some
that the people
individuals
ultimately will get an opportunity to decide.
to assert themselves and explain to the rest of the country what are constitutional values, why they should be upheld, and why they should not be compromised.
Right. Now as far as your lecture, the AG Nurani lecture, 2 points, very important points which you made regarding the Ayodhya case and the Supreme Court hearing, hearing and the Supreme Court judgment. The first is that you made this point that there was no prayer before the Supreme Court to build a temple for Ram in Ayodhya. Yet, despite that, the Supreme Court judgment gives a very elaborate direction, virtually, till the last dot, what all has to be done to build the temple. Can you explain, why are you saying that there was no prayer and where did the Supreme Court actually err?
See,
Why
this
did
was
they do it?
these started as suits for declaration of title and
Right.
declaration of possession, rights to possession
Yes,
of land.
that's exactly. It was called the title suit.
Yeah, it was a
That is
title.
when we
It's
first
all
heard it, when all the cases were lumped up from Faizabad to
Correct.
send to the Lucknow bench of the Allahabad High Court. It was a title suit.
This is a classic. If you start LLB course, you will be taught about the Transfer of Property Act, about the CPC,
Exactly.
about Evidence Act. All that is there in full display. Witnesses being, witnesses, expert witnesses deposing, land title to land records looked at, entries in the land records looked at. So for all practical purposes, these are actually suits of title and nothing more, nothing less. This is what the entire judgment tells us till the last page.
Right.
There were attempts to say that the land itself is a spiritual entity. The second
Swayambhu.
plaintiff,
That
the
is what I
second
think
plaintiff in the suit in the name of Bhagwan Ram. Bhagwan Ram is the first plaintiff. The second is the Janmasthan. So there was arguments to say, first of all, that the deity itself is Swayambhu. There are pages and pages of discussing
Yes.
this. And there is also an argument saying that the land, Janmasthan, is a spiritual entity and an entity on its own. So that also, this is negatived. This is negatived by the Supreme Court. At no point in time are the prayers in the suit, which are for declaration of title, those prayers are not added on to say, after having declared my title, please
He's
allow
given the
me
right
to
to
build a
build a
temple.
temple.
There is no prayer. So there is no prayer for building a temple at all. So normally when the civil court sits down to frame issues, it will look at the plaint, it will look at the written statement, it will look at the amendments that have been made and allowed to be carried out. Frame issues arising from that, right? Arising from the prayers in the suit. There is no issue, and this I might repeatedly tell all the viewers, there is no issue framed by a civil court, and you must remember that the High Court held the trial. The trials were shifted to a High Court. 3 judges of the High Court actually conducted the whole trial. There is no issue saying, in the event, as an alternative prayer, in the event that my title to the land is declared, either the mosque should be rebuilt or a temple should be built. There's definitely no prayer for that. So if you find towards the end of the judgment, I don't want to take up too much time, I'll tell you this. None of the pieces of evidence placed before the court, whether it was oral evidence or documentary evidence or historical ASI reports, none of them could assure the court that prior to the demolition, prior to the construction of the Babri Masjid, there stood a Hindu temple.
And that was demolished to build a mosque.
Yes, that question was not categorically answered through any of this evidence.
Right.
So you had an addenda just to say it could be faith and belief. But the majority, the main opinion, signed by 5 judges, including that judge who supposedly wrote that addenda, very clearly says the evidence doesn't tell us in clear terms that there was a Hindu temple which was brought down to build the mosque. This was the main issue. This was one of the main issues, and that was not able to be categorically answered at all. So the judgment then proceeds on justice, equity, and good conscience. A good deal of the last part of the judgment deals with, again, Article 142. This urge to do complete justice. Then you slip into preponderance of probabilities. Then you're again not satisfied. So if you see all the conclusions that they say on analysis of evidence, this is the conclusion. What they're able to conclude categorically is only this, that the outer courtyard was completely with the Hindus, where they worshipped on the Ram Chabutra, Sita Ki Rasoi. But the inner courtyard, namaz was being offered till 16th December 1949.
Yes.
So again, look at the finding is not able to step out of that, right? They've compelled to acknowledge that namaz is being carried out till 16th December 1949.
Yes.
And what happened in the eve of 22nd, 23rd, they categorically
is also categorically stated.
An illegal act.
Yes.
Likewise, they said 6th December 1992 is violative of the rule of law. A destruction of Babri Masjid in the teeth of the court orders is violative of the rule of law. This is all towards the end, right? Where all the conclusions are being drawn up. And then you have the act. See, there's no doubt that under the act, section 6 and 7 require a trust to be formed. But this is not part of the suits. This is not the prayer in the suits. The act came in 1993. They didn't amend the prayers to say, please form a trust under this act. So apparently what happened, and this is not written in the judgment. After I gave the talk, some people brought it to my notice. Apparently, one order was passed asking the parties to give their suggestions as to how relief can be molded. Right? This is not written in the main judgment.
Right.
And even those suggestions in those notes don't say that please issue a direction for construction of a temple. So if you read the judgment,
True.
you don't get to
No,
know
actually, it's such a
who
voluminous judgment that
asked
it
for
is.
this. Who asked for this? In the final relief, in the operative portion, the slip-in saying you within 3 months from the scheme for several matters, including the construction of a temple. You know, that line is slipped in, which did not come from any of the parties. And central government is not a party here in these
No,
suits.
definitely not.
And you're
So
giving
why
a
should the
direction to
central
the central
government?
government. See, normally in a court, you never give direction to a party, to a institution which is not a party before you. Central government is not a party before you. Central government could well have turned around and say, I'm not bound by these things, you never heard me.
True.
But it so happened here, this central government was not going to say that.
No, it was interested in getting that judgment. That's it.
So it's a mystery how this final relief that was carved out was worded in this way. And did all 5 judges, Nilanjan, it's a 961-page judgment
Yes.
on 100 pages, the
Huge.
main judgment. Then there are 118 pages of the addenda.
And
Add
all
the
written
two,
between
more than
the
1,000
16th
pages.
of, all
Yeah.
written between the 16th of
Right.
October when
Yeah.
the
Yeah.
last
Yeah. I,
hearing
in
was
fact,
there.
told the audience during the talk, remember this date of 18th October, I think, 2019. And the judgment is pronounced on 9th November.
20 days.
And
21
I've been a
days.
judge myself. I can't deliver a 1,000-page judgment in 10 days. Okay, one of us has written it, right? There are 5 of us. I have to give my draft to the other 4. They have to read it. And this is such an important issue governing the entire country. I'll be asked to believe that 1,000 pages were read by all the 5 judges, understood completely, and therefore agreed without any discussion amongst themselves on the draft. I mean, I find this all a bit,
Yes, you have raised some very, very awkward questions. One last question. I just want to tackle this very briefly. This entire thing about mediation. The Supreme Court did actually try to mediate. What you have pointed out in your lecture is something which I had missed out also in my numerous readings of the judgment, because possibly it's also slipped in somewhere. One would have to go back. Is that there was actually a final report where the UP Central Sunni Waqf Board, said that it was willing to relinquish all claims, it would not ask for any of its rights on that title. Yet there were certain conditions, but this was not explored by the Supreme Court. It just put a matter to the end and went around giving to what you have just explained, to the judgment, which actually raises several questions.
Yeah. So this, again, on mediation, like I said, see, in ordinary civil cases, even on a daily basis, it happens. Sometimes even in criminal cases where, the complaint is about cheating or
Yes.
a bounce check, people do say, listen, this is essentially a dispute about money. So why don't you go in for
Have an out
mediation?
of the court
It's a
settlement.
dispute about division of property. Why don't you? So this was a classic case. In fact, if you remember the High Court judgment, Allahabad simply trifurcated the properhag's.
Yes, in three parties. The three
Yamhara got one portion, the Sunni Waqf Board got one, and Bhagwan Sri Ram got another. So, and the
I've
Supreme Court
written
finds
this was
fault
the
with
best.
that.
This
Yeah.
was the best possible verdict.
Yeah, the Supreme Court finds fault with that, saying you can't do this kind of a thing. But what is the Supreme Court doing? It's saying that on the land where Babri Masjid stood, now we'll give it to the, for Bhagwan Sri Ram, and we'll ask the central government to build a temple there. And we'll give another parcel of land somewhere else for the Muslims to build a mosque there. Now, this they don't find to be problematic. But my point was this. Once you have, as a Supreme Court, constituted a mediation committee, this was constituted by them.
True.
And that committee is coming before you on 18th October to say, listen, there is this report. They're telling you that some parties have agreed. Some parties are refusing to sign. Now, we as judges, and we've done this, parties come to us and say, listen, they're very close to, or it's 70% through, 30% is left. If you sit with us, if judges sit with the parties, probably they can find a solution. Like I said in the speech, I'm not sure that they could have found a solution, but there was a possibility of that happening. Why didn't you explore that possibility?
Exactly.
This is all I'm asking. I'm saying you started a process of mediation. It reached a certain point. Merely because all parties did not sign on it, would you abandon that process? And you see, we have today a judgment. And as a scholar of law, and there are several people I've spoken to, there are some judgments which can constitute what we call a precedent. That is, you can follow it in other cases.
Yes.
But some judgments, you just can't follow it because the conclusion drawn in the judgment doesn't logically flow from the reasons given in the judgment.
True.
So then it can't constitute a precedent. This has turned out 1,000 pages, which we actually can't cite as a precedent. Why? Everything hinges on that Article 142, what they've done in the end, which sits at odds with the entire reasoning and conclusions in the judgment. So I'm saying if you're going to reach this point, you might as well have further pushed for mediation, explored that possibility without giving
This
us a
on
judgment.
something on a matter which had been going on for more than almost about 150 years as a legal dispute, right from 1885. It is something that some more time could have been spent to
Nilanjan,
find a.
yeah, in 1994, when 5 judges told us while declining to answer that presidential reference because it was
Yes.
not a question of fact, but upholding 3 by a majority of 3-2, they upheld one part of that Acquisition Act.
Acquisition.
Both the majority of 3 judges and the dissent of 2 judges, both those opinions say that negotiation settlement is the best way to go forward. Both
In
those
fact,
judges.
for a long time, we journalists, who were on the beat used to argue, or rather, that's what we felt, that the Supreme Court sent back the presidential reference because they felt that this should be sorted out either through negotiation or by the political leaders. That this was something where the judiciary had no role to play. That is what our colleagues who were reporting on the Supreme Court. That's the kind of feedback that they would say that they were picking up. So that is, you have raised some very important questions. What I am rather worried about, but we'll have to leave it that only at a state of worry, that hearing is still going on about Varanasi, about Mathura, about Sambhal, about the shrines in Bhojshala in Madhya Pradesh. So there are numerous cases. Places of Worship Act is being challenged. So there are all kinds of complicated cases going on, and as you say, that good judgments become precedents for the coming ones. Here we have a judgment which I hope that will not become a precedent for the cases which come up in Varanasi, Mathura, and numerous other places where people say that this mosque or this Islamic structure was built after demolishing a Hindu temple, and they should get their title back and also to build a temple. Well, thank you, Justice Muralidhar. It's really been an enlightening conversation with you. You have been able to shine the spotlight on certain areas of the judiciary which remain dark, at least in public perception. Thank you very much.
Thank you so much. Thank you.